Visiting Professor Eric David, thank you for giving us this opportunity to ask you a few questions with regards to the formation of an international tribunal in order to try Islamic Republic of Iran for the mass murders of 1980s. Could you possibly give me your opinion about such tribunal?
I think that this kind of experience is very important from different points of view. Firstly, it's a very important contribution to history with a big H, because it really helps people and the future generations to remember what happened in Iran during the 80s and the following years. And so I think it's a real contribution to history. This tribunal, of course, it's not a real tribunal. It's in French, I translate from the French, it's an opinion tribunal. It's in the framework of the Russell tribunals, which were made by the British philosopher Bertrand Russell in the 70s, even the 60s and the 70s. Firstly, you got sessions of the Russell Tribunal about Vietnam at the time of the Vietnam War. You get other sessions about Chile, about the DRC, about Iraq. And in fact, this kind of tribunal tries to bring a sort of legal judgment about facts which square with very gross violations of fundamental freedoms. And in this way, I think it's a very important contribution to the fight for the respect of rights, fundamental rights and freedoms.
Is it right for the Republic of Iran to attempt to justify their action by referring to Islamic law?
To say that I'm not at all a specialist in Islamic law. In fact, I don't know nearly anything about Islamic law, but I'm sure that, of course, Islamic law is not a legal system which allows so gross violations of human rights. And consequently, I'm quite sure that any reference to Islamic law is very likely a false reference. And anyway, even if Islamic law could be a kind of justification to these gross violations of human rights, anyway, these violations are violations of international law, and international law has primacy on internal law, including Islamic law.
What potential violations of international law will the tribunal consider?
Mainly human rights violations, that is, not only violations of rights and liberties that you can find in a number of international texts which bind most states, and certainly Iran among others. There is the Universal Declaration on Human Rights of 1948. This declaration is just a resolution of the General Assembly of the United Nations. As such, it does not really appear as a binding text, but today it's well accepted by all states that in fact this declaration is the expression of international customary law, and as such it is binding. For instance, if you think of the hostages case in 1979-1980 between Iran and the United States, it was quite interesting that the International Court of Justice did not hesitate to condemn Iran because this taking of hostages, the taking of hostages of the personnel of the diplomatic and consular American staff in Tehran was considered as a violation of the Universal Declaration of Human Rights. And the court did not say one word about the fact that this declaration is not stricto sensu, it's not a binding text. Because, in fact, the declaration appears, as I told, the declaration appears as a kind of expression of international customary law. And so if even the International Court of Justice accepted to refer to such a declaration, it's not at all an exaggeration, it's not at all excessive to invoke this declaration as a source which can apply to gross violations which have been committed by Iranian authorities. But next to that, you have binding instruments which do not raise any problems in this respect, and I'm thinking, for instance, of the 1966 International Covenant on Civil and Political Rights, which prohibits, of course, all the violations which have been committed by Iran. So you have there a first category of sources which apply to the facts which are attributed to Iran. But there is something more. The facts which are attributed, the behaviors which are attributed to Iran are not only mere violations, if I may say, mere violations of public international law. They are also crimes, and not just crimes in domestic law. They are crimes in international law. They can be easily considered as crimes against humanity, in the definition that you find in Article 7 of the ICC statute. And consequently, Iran not only engages its own responsibility in international law, but also its criminal responsibility. Not Iran as a state, of course, but the Iranian agent, the Iranian officials engage their own criminal responsibility for the acts they commit, and they could be prosecuted on the basis of universal jurisdiction anywhere in the world, because the crimes they have committed are crimes against humanity, and for these crimes you have universal jurisdiction.
Thank you, Professor Eric David, for being with us, and wish you good luck with your future work. Thank you.
Thank you. You are mostly welcome, and let's cross fingers that this experience can help the victims and the families to recover in a way or another. Thank you.
Thank you.